जैसा she said, कोई वजह ही तो नहीं थी, बिना वजह के तलाक दे दिया है. And she has of course filed a police complaint on 8th December. This is happening post 2019 when triple talaq has been declared completely illegal and unconstitutional in the country. I'm not making a political statement. This lies in the progression of history. This lies in the logic of history. I'll give you one very small example. I'm sure will hit the students to be able to understand why I say that this lies in the progression of history. See, I don't know how many of you have watched this 1982 blockbuster movie Nika. And you must have heard this song, Dil Ki Armaan Aansuon Mein Beh Gaye. So this is how the woman of the 1980s was. And if you look at the woman, the Muslim woman of 2016, you'll remember this song that has become iconic as the breakup song. दिल में पत्थर रख के मुंह पे मेकअप कर लिया, मेरे सैया जी से आज मैं breakup कर लिया. So this has become, you can gauge the transition that has occurred in the world, that has occurred in the domain of Indian women, that has occurred in the domain of Indian Muslim women. That the woman can come and see, दिल की आरमान आप आंसुओं में नहीं बह जाता है. Now she can say, दिल पे पत्थर रख के मुंह पे मेकअप कर लिया, मेरे सैया जी से आज मैंने ब्रेकअप कर लिया. So this is basically in a sentence that I would like to sum up the transition. Now, when we talk of the status and rights of women in Islam, we tend to be a little defensive, trying to say that Islam had given women a lot of rights when there was no rights for women in any community, in any society during the 7th century CE. Women had the right to property, perhaps when the rest of the world didn't know about women's right to property. But this is again being very defensive and about a system that refused to evolve post 7th century CE. If you look at the 1955-56 reforms in Hindu law that had happened in India, I would like to just state 4 of them. The Hindu Marriage Act, the Hindu Succession Act, that had come a long way from the Vedic times to the 7th century CE scenario where we, compare the Hindu and the Muslim rights, and then to 1955-56, the Hindu Succession Act, where we have to property. The Hindu Guardianship Act, the Hindu Adoption and Maintenance Act. Ambedkar had quoted Burke in the Parliament in 1951, and he said, if you want to maintain the Hindu system, Hindu culture and Hindu society, do not hesitate to repair where repair is necessary. Now, we understand the infallibility of the Quran and stuff. I'm not going into the religious aspect of the human rights that are the point that I am trying to make. Now, patriarchy bypasses Sharia law where it suits the patriarchy. I'll give you just two examples of this dichotomy. One is in terms of the interests earned on bank deposits, we try to adjust ourselves, and for punishment for theft. In cases of punishment for theft, we would see the other types of criminal laws being executed, not the Quranic law. But when it comes to women, we are very, very strict about how we want to execute it. And it is curious that, I find it curious, that the Indian Muslims are still guided by a colonial act, the Muslim Personal Law Shariat Application Act, or the Act 26 of 1937, in which certain sections of the previously prevalent acts were repealed. Like, I'll give a few examples. Like the Section 26 of the Bombay Regulation 4 of 1827, Section 16 of the Madras Civil Codes of 1873, Section 3 of the Audh Laws Act 1876, Section 5 of the Punjab Laws Act 1872, etc. These sections were repealed, and the Act 26 of 1937, or the Muslim Personal Law Shariat Application Act, came into being. These sections being considered inconsistent with the provisions of the Act. notwithstanding any customs or usage to the contrary, in all questions, save questions relating to agricultural land, regarding succession, special property of females, including personal property inherited or obtained under contract or gift or any other provision of personal law, marriage, dissolution of marriage, including talak, ila, ziyarah, lian, kula and mubarak, maintenance, dower, guardianship, gifts, trusts and trust properties and waqfs. The rule of decision in case where the parties are Muslims shall be the Muslim personal law, in brackets Sharia. Now, when we talk of the Protection of Women from the Domestic Violence Act 2005, that covers all Indian women. And when we are talking of the provision of the Child Marriage Act 2006, that came into force in 2007, that also brings under its umbrella the entire scope of the Indian citizens in the country. All women of India, irrespective of their social status, caste and community identities. Now, Islam does provide women to initiate the right to divorce. That is called kula. When we are talking of human rights and rights of women, we also got to know that women in Islam do have the right to initiate a divorce, which is called kula. But given the social taboos, the family resistance, the lack of support, initiating a divorce generally is not easy for anyone. For a woman, initiating a divorce, initiating a kula is relatively very difficult in the Muslim societies. Now there are two types of talaqs. I'll just go briefly into them. One is the talaq-e-ahsan, or the Quranic method of talaq, and the talaq-e-bidat, or the triple talaq, which was legitimized. Now what is the talaq-e-ahsan or the Quranic talaq? It offers the talaq one at a time. Divorce is pronounced one at a time. And quickest possible divorce or the talaq could be in 3 successive tours. Tour is the menses-free time of the woman. And the husband utters the divorce once. He can take it back. He can withdraw it during the waiting period, which is called iddat. And because 3 words of divorce have to be uttered, these are in 3 consecutive months during the tuhur, which is the menses-free period for the woman. Now, iddat of the waiting period assures that the woman is not pregnant. To confirm that the woman is not pregnant, or until the birth of the child if she is pregnant at the time of divorce. After the 3rd pronunciation of divorce, it becomes irrevocable. And then if the husband reconsiders his decision to take back the wife and agrees on remarrying the wife, he cannot take her back like that. That has to be a remarriage, and the wife has to go through a nikah halala, which means an intervening marriage before the triply divorced couple can remarry. I'm not going into the intricacies of nikah halala and human rights. I'll just concentrate on the triple talaq resource. Now, to the ancient jurists, to all ancient jurists, the body of the woman was of primary importance in any jurisdiction, in any statement that they were giving pertaining to law and marriage. The body of the woman was very important. Now, coming to talaq-e-bidat, this is triple talaq in one sitting. At one go, the husband utters talaq, 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 and it is considered to be a divorce. This is based on Sharia law and not based on Quran, but Sharia has legitimized it. This is when an incorrigibly acrimonious couple could part. This is for them, an incorrigibly acrimonious couple could part ways as quickly as possible. And I find it very interesting that we find an exact parallel of this in Kautilya's Arthashastra. In Kautilya's Arthashastra, divorce is called moksha. What a liberated word for divorce. Moksha. And it says parasparam dveshan moksha. If the couple is vitiated against one another so that there is no chance of reconciliation, give them the divorce, liberate them immediately. Dveshan moksha. If they are wished towards each other, if the feeling is of wish, they should get immediate moksha. Now, all the four schools of Islamic jurisprudence, the Hanafi, Maliki, Hanbali and the Shafi'i recognize it. They consider it sinful but effective. In the villages, I had done extensive field work when I was working on triple talaq. There are rustic, village couplets like Ain talaq, Bain talaq, Arjun with Dam talaq. So you utter this talaq word thrice and talaq becomes effective. I have seen personally in my field work in the villages of Birbhum, Murshidabad, because these are the two districts where I had done my field work. In a feel of anger, in the drunken state, as a joke, divorces are uttered. But if there's a witness, that stands final for the woman. And that is why I situate it in the domain of human rights. The daily laborer comes back home after a hard day's labor, asks his wife for food, and finds a strand of hair in the meal. He utters divorce. He says talaq, talaq, talaq. And we don't know where the woman will go. Food not being served in time. I have interviewed a woman who had given just 20 rupees, a 20 rupee note to her brother who was going back to her village, to her parents. And the infuriated husband, because he thought this was disobedience, this was obstinacy, divorced the woman because she had taken an independent decision. You can understand that these generally are in the lower socio-economic groups of Birbhum, Murshidabad and the South 24 Parganas. But this is the general rural scenario that I had seen in West Bengal. In the comparatively upper strata, triple talaqs have been served through speed post, through SMS, via email, WhatsApp, Skype, etc. Even where divorce doesn't take place, it is like an open dagger dangling above your head. One is the perpetual threat. There is an emotional violence. I'll divorce you, and divorce is so easy that the husband utters talaq, talaq, talaq. There happens a divorce and the woman doesn't know where to go. And secondly, there is a perpetual insecurity. With the arrival of another woman in the life of her husband, or incurring the displeasure of the man, there could be a divorce at any time. In 22 Muslim countries of the world, there has been no triple talaq. Verbal triple talaq or talaq-e-bidat is forbidden. I'm not going into the details of these countries, but they had formed this jurisdiction on the basis of the Hanbali jurist Ibn Taymiyyah, whose time period was between 1268 and 1328. Towards the end of the 13th century, he had said that 3 talaqs in one sitting should be regarded as one. And taking cue from this, Egypt in 1929, Sudan, Syria, not the Syria of today, Syria in 1953, Iraq, Jordan, Indonesia, UAE, Qatar had accepted Taymiyyah's position. Now, this was not something new that had come. I'll give you a series of examples from the verdicts that had come, again in the logic of history, that culminated during 2017-18. In 2002, in the Shamimara versus the state of UP case, Justice R.C. Lahoti of Lucknow High Court had spoken strongly against this instant triple talaq. Way back on April 15, 1994, Justice Harinath Tilhari of the Allahabad High Court had held that I quote from the verdict, triple talaq is discriminatory towards women and therefore constitutionally not valid. This was 1994. In 2002, in the Daddu Patan versus Rahim B case, Justice B. Madapalle of the Aurangabad bench of Bombay High Court invalidated triple talaq by citing the Quran. In 2008, Masroor Ahmed versus State, Delhi High Court Judge Justice Badar Ahmed say triple talaq in one sitting should be considered as single and revocable. In the Ziauddin Ahmed versus Anwara Begum case in the Guwahati High Court, the judge noted that talaq should always be for a reasonable cause and must be preceded by attempts at reconciliation. So we have examples, again the logic of history, the historical trajectory that was being built up from 1994. This resurfaced again when a woman called Shaira Bano. Shaira Bano is from Kashipur in Uttarakhand. She is an MA in sociology and she was married to a high school graduate, Rizwan Ahmed, in 2001. They had 2 children. Her in-laws had taken away both children and she was subject to domestic violence from 2001 to 2015. She had borne it, and this is what most women in our country, irrespective of the communities, actually bear. And this is why I thought I'd raise this topic in a discussion in an international seminar on human rights. Even our courts think that if there is no complaint of domestic violence during the first 7 years of marriage, everything is going fine. But this woman had endured domestic violence for 15 years, and I had the chance of interviewing her. I met her. She's had 6-7 abortions, she said. So when I asked her about the exact number, she said, from what I could make out from what she said was, she had lost count because of the tremendous domestic violence that she had been subject to. But in April 2015, the demand for dowry, the torture became so unbearable that a traumatized Shaira Banu returned to her parents' home in Kashipur. And when I interviewed her, and then I'll tell you what happened exactly, then I'll tell you what she said. In October 2015, Rizwan sent a speed post from Allahabad to Kashipur, and the Mufti, the local Mufti, certified and regarded the triple talaq as valid. So this is what happened to Shaira Banu, and she moved the court. And when I spoke to her, she was so apologetic, she was so defensive that it was she who actually initiated the movement. And she said, "मेरे खानदान में पहले कभी किसी का तलाक नहीं हुआ है." So this stigma of divorce that we attach with women, we attach with families that have gone through a divorce, and this family was still planning to send her back until they got this letter of triple talaq from the husband in 2015. She filed a writ and urged the court to declare that triple talaq was illegal and unconstitutional. Now, I would argue that the talaq-e-bidat, nikah halala and polygamy are violations of Article 14, 15, 21 and 25 of our Constitution. And these are not part of the Quranic rights, neither are they part of the constitutional rights, nor are they part of human rights. And this is again another reason why I decided to take this up on the Human Rights Day. The Universal Declaration of Human Rights, Article 16, Clause 1 states, I quote, "Men and women of full age, without any limitation due to race, nationality and religion," I underline religion, "have the right to marry and to found a family. They are entitled to equal rights as to marriage, during marriage and at its dissolution." So where do we get the equal rights at the time of dissolution? Now with Shaira Banu, we have another example from Afreen Banu, who was an MBA from Jaipur and was married to an Indore lawyer in 2014. In January 2016, she was also served divorce also. On October 7, 2016, the government filed an affidavit in Supreme Court report stating triple talaq was, I quote, unfair, unreasonable and discriminatory. Gender equality and dignity of women are non-negotiable and can prove no compromise. Now this was looked upon as one, a great Hindutva-vadi conspiracy to hegemonize the nation, and secondly, a section of the secular liberals also thought that it was a matter of religious right of the minority community. It was a part of the religious culture, and therefore Muslims have the right to be left alone. Let the Muslim leadership, which is essentially in the hands of the religious leaders, not in the hands of the secular progressive leaders, let the religious leaders decide. The self-proclaimed custodians of Muslim law, the guardians of Muslims in India, for instance, the All India Muslim Personal Law Board, which is no more than an NGO, which has no constitutional basis. Let AIMPLB, All India Muslim Personal Law Board, decide what they want to do with their women, othering the Muslim women from the rest of the Indian community. This othering the gender discourse of Muslims. Now, what was the role of what were the arguments of the All India Muslim Personal Law Board? If talaq is a time-consuming process of 3 months, the All India Muslim Personal Law Board argued, number one, the man may, and all this came from the press briefings of the All India Muslim Personal Law Board. You may go back and check if I am wrong. One said, if talaq is a time-consuming process and the man is, annoyed with the wife to that extent, one, he may murder his wife or burn her alive. One. Two, if family matters are dragged to the court, it will reflect on the character of women, character of their women. Therefore, that would be in utter disregard of izzat. It would be a matter of grave concern, of great beizati to the woman and to the family, therefore. And third, it is always a male privilege to decide on divorce, implying that women are passive partners in social institutions like family and marriage and play only a secondary role. A similar argument is still put forth in the context of punishment for triple talaq. Now that triple talaq has been banned, has been declared illegal and a law has come into force, the strongest argument in favor of